Okay, so the College Board and Supreme Court cases. Up until the restructuring of the exam for last year's exam, there was no set list of court cases from the College Board saying you must know these. There was conventional wisdom of the biggies like Marbury versus Madison and McCulloch versus Maryland, and they invariably, most often, ended up on a multiple choice question. And then occasionally they'd pull other famous cases and occasionally not so famous cases. There was several years ago, they were talking about the Fourth Amendment search warrants and they brought up Wolf versus Colorado. Um, and it's one of the three major cases about how to deal with search warrants. But it's by far the lesser of the three. The first was Weeks, which established the exclusionary rule that evidence that they obtained without a search warrant, which you see talked about on every cop show imaginable, would be excluded from a trial. And then the third case is Mapp versus Ohio, where they told the states they had to that they would be subjected to that rule as well. But if evidence in a state court, which is where most criminal cases are anyway, if you got them without a search warrant, then they could be excluded. And we'll talk specifically more about that in a later lesson. We'll talk, I'll talk, you'll listen. Um, in between, in the late 40s, there was a case, Wolf versus Colorado, where they told the states you have to obey the Fourth Amendment. In other words, you're supposed to have search warrants before you search through people's property. But they didn't apply the rule that said if you found stuff without it, it was excluded. So that was an example, and that kind of threw everybody off. Teachers were sort of upset. So one of the things they did in the restructuring was they have designated a list of 15 cases that you must know about. The primary purpose is that at least one of those cases will be used in what's called the SCOTUS FRQ. That's question number 3 on the standard test, which you're not getting this year. It would also be a hint that these could be cases that might pop into a multiple choice question, or I'm thinking maybe if they want to get away from the founding documents, which is what they've done the long FRQ on, they could perhaps, in those things that you have to talk about, throw in one of these court cases. So in this video, I'm going to walk through sort of the basics of what each case is about, and I would say half or more we have already touched on at various points in talking about the evolution of American government. Some we haven't yet because we haven't gotten to the Civil Rights and Civil Liberties unit, which is still something I need to record later this week. So that's how we'll proceed. You got to feel comfortable with, you know, what the case is about. You know the core decision, and then when I go through these, I want to talk about how could they, and some of these cases are decades old or centuries old, how might they relate to something today? So those are the elements that you need to be aware of. Okay, I've clustered the cases together by the general topic that they deal with, and this first slide shows you the two cases whose primary topic is the issue of federalism. One from obviously the founding period of the Marshall Court, 1819, and the other Lopez from the 1990s, so almost a 200-year spread. You'll also notice there are links to summaries of these cases that includes background documents, etc. on the OIA site. Excellent source. If in this discussion is not enough and your text, feel comfortable with the textbook, click on those links and there will be everything you ever wanted to know about those cases there. McCulloch versus Maryland is one of the landmark cases of the entire Supreme Court, of the entire evolution of American government. You know the Jeffersonians, as they had evolved, gave in on the idea of a national bank. Madison, in the conducting of the War of 1812, suffered from the fact that the original bank was done, and financing the war became a major hassle. So grudgingly conceding to Hamilton the usefulness of a Bank of the United States, They passed the second Bank of the United States, and actually, I think it was at least 3 times as large financially as the first bank. There were still, more dedicated Jeffersonian small government, small national government Jeffersonians who wanted to fight this. And in this particular case, in Maryland, the state of Maryland tried to drive the U.S. bank out of business by applying an excessive tax on it. McCulloch, the manager, this was sort of a setup case. This was all sort of prearranged to challenge this and take it to the Supreme Court. Um, there are two aspects of this case from the federalism perspective. One, in ruling on the bank's constitutionality, in creating a rough guideline for what necessary and proper meant, it opens the door to, down the road, decades, a century or more later, the federal government using necessary and proper clause to expand the areas in which it could make law. And then the second part of the case, touching on the supremacy clause, made it very clear that when the federal government is exercising constitutional powers, it takes priority over the states. So that it's not like the next day after this decision, the federal government was passing one law after another, dominating the states. It would take the better part of a century and a half for that to develop. And there were cases in the 1930s. There's a famous case, Wickard versus Filburn, when the Agricultural Adjustment Act was trying to keep prices stable by limiting how much farmers could produce. Well, one farmer was growing some extra crop that all he didn't sell it, he didn't put it on the market, but he used it to feed his livestock. I don't remember if it was cows or pigs. And he was prosecuted by the federal government, and the court issued a ruling saying that not engage or this still was constitutionally allowed, because if he followed the rule and only made the appropriate amount of grain, that in order to feed his livestock, he would have had to maybe purchase some grain, and that purchasing would have helped pricing, and stabilizing the pricing of agricultural goods was a proper use of the Commerce Clause, and thereby had to follow it. Then, of course, we've mentioned previously, and we'll mention again in the next couple video lessons, in 1964, the Civil Rights Act was challenged. Businesses, private entities were told, you cannot discriminate based on somebody's race, religion, or ethnic origin in your business if you are engaged in interstate commerce. The court ruled in 2 cases that was indeed a constitutional exercise of regulating interstate commerce, sort of like creating the national bank, the second bank in the McCulloch case. And they gave a very much like with the poor farmer and his livestock, they gave a pretty broad understanding of that. We talked about the case involving a small little restaurant in rural Alabama, that yes, you, Ollie, in your restaurant qualify as being engaged in interstate commerce. And that's the 60s, and that kept into the 70s, into the 80s. But with the rise of Reagan and the neocons of the Republican Party and the ability to put more conservative originalists on the court, the degree of that flexibility was sort of questioned, and the landmark case from the early 90s is U.S. versus Lopez. I think we'd mentioned this before too. The Congress, in order to show as part of the crime bill, they were identifying with violence and guns, etc. So they passed a federal law under the justification of the Commerce Clause that you could not possess a firearm on school grounds, state public educations. And this would apply to all 50 states, every public school, everywhere. And it was challenged, and the court rejected the Commerce Clause. So for the first time, the court sort of began to rein in this broad acceptance of anything as interstate commerce, and therefore could potentially be regulated by the federal government. We're sort of still in that trend. Now, of course, since this time period, we've gone in these 8-year swings of a Democratic president, a Republican president, Democratic president, Republican president. So what the federal government's trying to do has been affected by those swings. And then, of course, the timing of judicial appointments. I do not think Kavanaugh and Gorsuch will take the court back into a 1960s direction regarding interstate commerce. I just don't think they will. If Joe Biden is elected and the next several justices are appointed by him, then maybe that could change. Okay, this slide, you'll see the cases are titled under the category of civil liberties. In the next two videos, two or three videos, depending on how I break it down, we'll go into a little more depth as to the difference between civil liberties and civil rights. Just quickly, civil liberties are items in which you are free as much as possible from government interference in your choice to behave, think, do things in a certain way. These are the four cases that the College Board chose to put on this list. I don't know if I, particularly the Shank case, would bother to put that on the list, but whatever. So let's run through. The first one is Engel versus Vattel. When you are in a public setting, you should be free from government imposition of religion, in this particular case, school. And it was sort of the final in a series of cases where the court was laying out a standard of no prayer in public school. In this particular case, New York State, looking at the previous decisions, had, that we're talking about schools reciting the Lord's Prayer or something like that, a biblical reading. And okay, we get that. So what we're going to do, and what they did was they wrote this really generic, you can look it up, it's called the Regent's Prayer, that would be recited in New York State public schools. Very generic, very bland, but still with overtones of religion. So it went to the court, and the court said, no, you're still not getting it. That the person who might be Jewish or atheist or Muslim is going to be intimidated in a school setting by, over the public address system, this very Christian-orientated prayer is mandated to be recited, and there's going to be a lot of social pressure on the kids in class, granted it's 1962, to recite the prayer as well. So that's Engel versus Vattel. The Yoder case. Seemingly following the principles of equal protection, I believe it was Pennsylvania, said everybody has to go to public school, we're paying for it, you all have to go, or an appropriate substitute from grades 1 to, I forget what Pennsylvania set the rule at. But anyway, it conflicted with the Amish. The Amish people felt like, this was Wisconsin, not Pennsylvania, felt like at a certain basic education they were willing to accept, exposing their children to 1 through grade 6 perhaps education, but they felt their lifestyle and their morals demanded that they take the education from that point on. But I think Wisconsin at the time required to the 8th grade to the 9th grade or to the age 16. So the court, defending the free exercise of religion and the rights of parents to provide appropriately tailored education that meshes with their religion, that these Amish people would get an exclusion, a carve out, to be free from this requirement. And this can come up because, what you start carving out exceptions, when do you stop? But this is the famous Yoder case from the early 70s. Tinker versus Des Moines, and you see a picture of the brother and sister, were two high school students who wanted to protest the Vietnam War by wearing those armbands. This was a violation of the dress code. This was a disruptive. They were going to be suspended. It goes to court, and there's a famous line, I forget which justice wrote it, that the Bill of Rights doesn't stop at the schoolhouse door. However, because you're a minor, because your parents are still responsible for you, because the school has certain legal responsibilities for you, your Bill of Rights protections may not be robust as if you were an 18-year-old living on your own. But they're still there. And in this particular case, the court looked at the facts of the case. This armband wasn't horribly disruptive. It was related to political speech, and therefore these students have that right. New York Times versus the United States was the Pentagon Papers case. If you can remember from U.S. history, somebody who was working for a corporation doing a study of the Vietnam War decided this is terrible, all these lies that were told, and he snuck the papers out of the Pentagon and released them to the newspapers. The newspapers wanted to publish them. I think there was even a movie with Tom Hanks about this, and the U.S. government tried to stop them, tried to do something called prior restraint. And the ruling was that the freedom of press is the freedom of press. And, you didn't want to publish, should have done a better job locking the file cabinets. That this was, you could make a national security argument for prior restraint, and occasionally it would work, but this was talking about, this was a report on lies that were told in 1963 and 1964. And yes, it might embarrass the government. Too bad. Suck it up. Freedom of press really means something. In the years after 9/11, word got out about various means being used by the United States government to interrogate potential terrorists. They were being held in third countries. Poland, I believe, was one, and they were being subjected to waterboarding or other enhanced questioning techniques. Somebody didn't like that, leaked it, I believe, to the New York Times. The New York Times is going to publish a story. President Bush called the publisher of the New York Times and more or less begged him, please don't publish it. We are getting valuable information, da 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 da. And he said, well, I thank you very much for your phone call, Mr. President, but we're publishing it anyway. And based upon the New York Times ruling, that was all the president could do was ask. And the publisher decided to publish it anyway. And then finally, Schenck versus United States. This was one of the earliest cases involving civil liberties. This was a World War I protester advocating for not cooperating with the draft, and he was prosecuted under the various sedition acts passed during World War I. And the court established the first real standard for when is freedom of speech limited. And the standard was referred to as the clear and present danger test. If your speech presents a clear and present danger to the safety of the community, the nation, etc., your speech could be limited, and if you violate that, you could be punished. And on its face, that doesn't sound so bad, but the problem was the government got to decide what a clear and present danger was. So the benefits were all in the corner of the government making these arguments, and for decades after it was pretty easy for Congress to pass, for a legislature to pass laws restricting freedom of speech and just saying it's clear and present danger. In the 1950s, sort of bringing it forward, in the 1950s, when we had the second Red Scare, the court did ultimately change its mind a little bit in that early 1950s laws, if you talked about communism at all, it was perceived to be a threat, a clear and present danger, and you could be punished for it. Eventually, in a case from 54-55, the court ruled that teaching about the concept of communism was part of the educational process and would not qualify as a clear and present danger. Trying to recruit members into the actual Communist Party to be part of some organized attempt out of Moscow, even though pathetically organized, could still be potentially ruled. And this goes into, and this is where they could maybe take this case and tie it to a present case. In the late 1960s, the court did almost a 180 on the burden of proof for denying freedom of speech. And I just had the case escape me. Brandenburg versus Ohio. I believe it was a neo-Nazi giving a speech, was arrested. Again, the world turned upside down. Now it's a hard right person being arrested for their speech. And the case goes to the Supreme Court, and you would think, certainly all the hate speech of Nazis, it would be still, a clear and present danger, and Brandenburg would have gone to prison. But the court reversed and set a new standard called, listen carefully, imminent lawless action. That the consequence of the speech needs to be so inflammatory that right then and there, illegal activity is undertaken based upon being motivated by this speech. A riot ensues, somebody is killed. In that case, the speaker could be punished. Now, I don't think there's any set time, but it's not very long if some minutes later, somebody who is so inflamed goes out and finds somebody who they feel like has been identified by their speaker, go hurt this person, and they kill that person. They're obviously going to be in trouble for assault, for murder, etc. But the speaker is not. Um, any intervening time, unless he incites a riot, incites an illegal activity right then and there, his speech is protected no matter how obnoxious it is. So those are the civil liberties cases. We'll encounter several more when we get to that section in the video to come. Okay, next up are cases associated with the 14th Amendment. We'll go into more detail about the 14th Amendment, or I will go into more detail about the 14th Amendment in the civil liberties and in particular the civil rights cases. For our purposes, we're focusing on the first section. It establishes in the Constitution a standard for being a citizen. And Donald Trump doesn't like it, but the standard is you have to be born here. And if you are, you're a United States citizen. And by the way, you're eligible to be president. And it also says that if you have been naturalized, and naturalizing citizenship is in the Constitution, the right to create a system for that. Largely, it was one not terribly often exercised by the U.S. government until the early part of the 20th century. But they do set the standard for naturalization. However, once you are a naturalized citizen legally, with the exception of becoming president, you are treated under the Constitution the same as a native-born citizen. And what does that treatment entail? The first part was the privileges and immunities of all citizens. We've talked about this before, just very briefly, don't want to waste a whole lot of time. The authors of the 14th Amendment anticipated that that would overrule a case called Barron versus Baltimore, where the Marshall Court said the Bill of Rights, Amendments 1 through 8, only protect you from the national government, not state governments. As part of reintegrating at a certain standard the southern states into the Union, they wanted those rights, all of them from 1 through 8, to apply to the states as well. And they thought they did that through the Privileges and Immunities Clause. The court decided not to interpret that way, and they went down a much more complicated route that we'll talk about in the next two sections. The other things you get from being a citizen under the 14th Amendment is that the states must provide you the equal protection of the laws, and they must provide you due process. And in both cases, the devil is in the details. So let's talk about the 4 cases mentioned here that they have decided to pull from a vast array of potential cases. The first one, and I urge you to watch the video that I referenced, is the Gideon versus Wainwright decision. This was sort of the beginning of a series of what protections do you have when you're in the criminal justice system. Up until that point, they had been focusing on what several justices have referred to as fundamental rights, i.e. the First Amendment. With Gideon and MAP, which have to do with illegal searches, they start to focus on what do you get as a result of the Fourth, Fifth, and Sixth Amendments, even to some degree the Seventh Amendment, even the Eighth Amendment, because by the end of this decade period, they're now talking about when or when isn't the death penalty permitted. So this was a landmark case in imposing a national standard on the state judicial system, the state law enforcement system, based on applying one at a time the rights mentioned in the Fourth Amendment through the Eighth Amendment. This one had to do with the right to a lawyer. And you have a right to a lawyer, but what happens if you can't pay for one? If you watch the video, you see the argument is by the latter half of the 20th century, the legal process is a very complicated process. The reason I want you to watch the Gideon video is for 2 aspects of it. For the judicial branch aspect of it is when he sends his petition until he gets the phone call, that's for the process. Comparing his initial trial to the trial that occurs at the end is sort of evidence to justify that it is a big difference when you have a lawyer or not have a lawyer. And the court set a standard, a very expensive standard, as you'll hear mentioned in the film, that you must be provided that to fulfill the expectations of the 14th Amendment, to guarantee you have a fair trial, you have a right to an attorney. And this is the transition from civil liberties to civil rights, things that you can expect from the government, in this case based on the 14th Amendment. Many of these, were controversial within law enforcement, etc. But as general principles, people absorbed them and said, yeah, maybe that's not a bad idea. Where using the 14th Amendment to set a national standard really becomes a hot topic is Roe v. Wade. When they interpret the 14th Amendment, the due process clause of the 14th Amendment and they don't just decide, they don't say having access to an abortion is a police power, health, safety, and morals of the community, and each state is free to decide whatever they want. But they also don't go the other way and say that control over the fate of a fetus until birth is completely, from day one until right before birth, in the hands of the mother. They come up with this incredibly complicated decision. All 9 justices write an opinion on it, piecing together sort of what 5 can somewhat agree to is the trimester system, that in the first trimester it should be almost entirely the decision of the woman. In the last trimester there is more opportunity using the police power for the state to intervene, and in the middle trimester, who the heck knows. What they set themselves up for is decades of states poking and prodding and pushing various restrictions as to, particularly that middle trimester, what can we do there or not there. And we've seen even recently states pushing more into the earliest part of that middle trimester, if not the end of the first trimester, and really testing the Supreme Court. Do you still maintain those standards? In the, I want to say, the late 80s, there was a case, Casey versus Planned Parenthood out of Pennsylvania, where what could be as the best possible sort of standard they come up with at the time, written by Justice O'Connor, was the undue burden standard. If the rule or regulation provides an undue or presents an undue burden to the woman exercising her constitutional right to an abortion, then it's unconstitutional. Now, undue is sort of like beauty; it's in the eye of the beholder. More and current cases going on have to do with Texas and I think Louisiana, telling abortion clinics that if you want to offer abortions, you have to have a medical staff member who has admitting privileges at a local hospital. Well, very few do, and that was, the argument. Oh, it's safety. We're about safety. No, the real reason was they knew most didn't, and it would reduce the number of clinics in their state from, say, 20 to 2, on the road to none, potentially. That case is sort of frozen in time because of our coronavirus crisis right now, and those evangelical Christians who supported Trump through thick and thin are hoping that they're going to get a benefit from him getting Gorsuch and Kavanaugh on the court. And we could have, who knows what, Roe v. Wade just completely overturned, and we're back to the states deciding what they want to do independently. We could have a loosening of the undue burden restrictions. So, essentially almost the same thing would happen. You just couldn't have a state necessarily saying no abortions under no circumstance. We'll see. McDonald versus Chicago is sort of your lifetime version of this, the 14th Amendment. This is the applying the Second Amendment. First of all, they had to decide, and they did in a previous case, Heller, that despite the fact that the Second Amendment opens with talking about a militia, that the right to have arms, to keep and bear arms, is an individual right. Now, that case was setting the principle that it's an individual right. It came out of the District of Columbia, so it only applied essentially to the District of Columbia and federal territories. The following, I believe it was the following year, they applied it to the states. In this case, Chicago, operating under permission of the Illinois state legislature, and their restriction, I believe it was on handguns. So for the last decade, states have had to tread lightly on restricting firearms. And again, the NRA group who backs Trump, hopes that the presence of Gorsuch and Kavanaugh on the court will keep all those anti-gun laws passed after Sandy Hook, passed after Stoneman Douglas, tamp them down. And the last one, you should not need any review on this. Brown versus the Board of Education. Completely reverses the Plessy versus Ferguson decision. It's notable because it's proceeding on something called substantive due process. We're not looking at procedural due processes are the steps being followed. Is step one before step two, before step three, so on and so forth. It's not asking about the fairness of the law. So they eventually concoct this thing called substantive. The substance of the law, is it unfair? And you read the decision in Brown, what they're essentially saying is even if you could have absolutely duplicate educational facilities where quality-wise there was no difference, by telling two races that we are identifying you as different and on behalf of the government sending you to different places, that in and of itself is in violation of substantive due process. So stop it. And you know from various lessons you've had over time that that was a long and drawn out fight, but it was begun in the 1954 case of Brown versus the Board of Education. All right, and this last group of questions are labeled under political matters. The first one we've obviously talked about a great deal, Citizens United versus the Federal Election Commission. This case was originally about a part of the McCain-Feingold, the BICRA Act of 2020, that had blackout periods for outside groups putting on broadcast commercials 30 days before primary, 60 days before the general election, to ensure that it would just be the candidates and the political parties that you would be hearing from on broadcast television leading up to the elections. Citizens United had created a anti-Hillary documentary that it actually wanted to put on a pay-per-view, but it, I guess, still qualified. They challenged the law. The court had been trending, very protective of free speech, and so a lot of people anticipated that they might win the case, and this part of citizens of the BICRA law could be tossed out. What shocked everyone, well, several things shocked people. First was the court ruled that the blackout periods were constitutional, but completely out of nowhere, they decided that political participation also now applied to corporations and labor unions, even though laws had been on the books for decades forbidding, going back to the 40s, labor unions from directly spending on political activity. So when I say that, they could not put on United Mine Workers support, please vote for Smith for Congress. They could, after 1974, create a political action committee, make a donation, but they couldn't directly politic. They weren't like you or I as individual voters and citizens. Corporations, the law dated back, I think, to the time of Woodrow Wilson, roughly about that time, so about 100 years. So Ford Motor Company could not just directly spend on promoting Biden for president. They would have to form a political action committee, donate legally through the various political entities. They were now considered to be treated. Now, that in and of itself was controversial. However, despite everyone's concern, neither unions nor corporations have spent lavishly. What happened, why this matters, is the Federal Election Commission interpreted the movement of the Supreme Court in this direction to allow for anybody, corporations or wealthy individuals, to form a legal group under IRS laws, and they could then advocate, depending on whether they were being taxed or not, they could advocate on political issues, promote political participation, or if they were willing to accept that they would be taxed, they could promote a candidate or a series of candidates or a political party. These organizations, while existing under IRS codes, the 500 codes that we talked about, um, were largely ways that unlimited amounts of cash could be spent. They were nicknamed by God knows who, the media or somebody, super PACs. So they took the Political Action Committee title that was a legal entity created under the 74 law and managed by the Federal Election Commission, and they applied it to these IRS organizations that were created as a result of Citizens United. By taking that PAC, combining it with the word super, and then in casual conversation talking about super PACs, they have forever confused high school students. A super PAC is just a nickname for these IRS code created entities that promote political activity. It's not a legal term that you don't register as a super PAC. So that is all the consequence of Citizens United. And we go back, way back to 1961, and these are the series of cases, and Baker versus Carr is the one they've chosen to cite, where the court looked at something called malapportionment, that states were either on purpose or just because they didn't want to update things, ending up with all sorts of legislative districts of incredibly different sizes in terms of population. You might have a district with 1 million people in it, and the next district over might have 37,000 people in it. By the 1960s, the court, the liberal Warren Court, had had enough of this. And they said for everyone's vote and participation to matter equally, here they're using the Equal Protection Clause, the legislative districts must have roughly the same number of people in them. The very sexist phrase used was one man, one vote. So from that point after, when lines were drawn, you just couldn't use rivers or counties and not worry about how many people. You had to take how many people are into an account. It made gerrymandering much harder. And I don't know, and in 2 questions there, how much depth they're going to have an opportunity to go into. But probably the biggest impact was to all of a sudden, in one swoop, in the 62 and 64 election cycles, because all the districts had to be updated, give major representation now to urban areas who had largely been neglected and were unfavored in most states' political systems to the more traditional agricultural areas, which should, with the rise of Great Society, the fact that Great Society programs go steaming through with no hesitation is evidence of just how that urban, liberal, minority perhaps orientated power expressed itself immediately as a result of having to shift districts. Now the next case, Shaw versus Reno, has to do with when you are dividing up these districts. Now you've got to take into account the population for political purposes, what we've talked about for months as gerrymandering. The court has made it very clear, and in this case in particular, that you can't use race, a voter, a neighborhood's, an area's race, as the primary means for putting them in or moving them out of a particular district. Now, where this becomes challenging is when we're talking about African American voters, who, in addition to being African American, are also predominantly Democratic, because Shaw versus Reno reinforced the pre-existing feeling on the part of the court, which has not gone away despite coming close recently, that it's okay to gerrymander based on population, based on political party preference. So the battlefield precinct is 97% Republican election after election. And you move it out of a district to make it less Republican, you move it into a district, but you manipulate it because of that. That is constitutional, as long as you don't take into account the racial makeup of the battlefield precinct. Well, how do you separate, particularly with the African American voters? You say, well, we move them because they're Democratic. We didn't notice they happened to be African American too. And this has caused case after case after case, and you see the map there. North Carolina has tended to be ground zero for these challenges. Oh, they occurred all over the place, and not always because a racist legislature was trying to harm African Americans. There were cases out of Georgia where they wanted to guarantee um, at least a couple of seats in Congress coming out of Georgia would be African American, and rather leave that up to chance, they carved out two predominantly African American districts. One district ran from the Atlanta suburbs all the way to Savannah. They called it Sherman's March to the Sea District. Those got thrown out. So it doesn't matter what your motivation is. You want to try to ensure African American representation, or you want to prevent it entirely. If you're using race, you're going to lose. And we've had to redraw districts in Virginia, in the roughly Richmond to Virginia Beach area, because the state has lost cases trying to defend that we were just doing it political and not racially. Now, there was a case recently that came before the court where they thought they had figured out how to determine when political gerrymandering had gone too far. And Justice Kennedy had expressed in the early 2010s an interest in doing that. He was sort of the swing vote, the fifth vote. And he sort of hinted that I'd like to rule against it, but I don't know of a particular standard we can use. Well, we now have supercomputers and incredible mathematicians and AI, and somebody out of, I think, the University of Wisconsin actually came up with a formula. And it went to the Supreme Court, and it just, one of his final moments on the court, it just wasn't enough to sell him on. We now have a way to determine when political gerrymandering has gone too far. You could also argue this is a political question issue in that we now have a lot of states, including Virginia, either have or are considering depoliticizing gerrymandering. California, Iowa for a long time has done this. So there may be a feeling on the court too, rather than get in this political mud fight between, in this case, Democrats and Republicans, or red states and blue states. Let's let the people work it out. They really are upset by these entrenched political parties and candidates, then they can force the issue, and we'll see how this goes in Virginia. Of course, everything is sort of on hold because of what's going on with the virus. And of course, the last one is the granddaddy of them all, and I don't think the College Board expects you to relitigate whether or not judicial review is constitutional. I think most historians agree that the framers intended this as a role for the court, but it was such a hot topic given the anti-federalists jumping all over the idea of lifetime appointments and an over-powerful federal government. It wasn't anything they could incorporate into the Bill of Rights. I think the fascinating thing is that the cleverness that John Marshall used. Jefferson was one of these anti-federalist questioners of the lifetime appointed federal judiciary in an overly powerful federal government nation. So if in order to obtain that, you'd had to have ruled something the Jefferson administration did was unconstitutional, Jefferson would have been tempted and might have just ignored it. But Marshall was clever. He tricked him. He won the case. Madison won the case. Madison did not have to deliver the appointment of Marbury. He did not have to do something to help a Federalist politician and to help the Federalist Party. And the reason he didn't have to do it is the law that said it could be done was unconstitutional, and we have the right to determine what's constitutional. So it sort of boxed Jefferson in. How could he complain about the result in a case that he won? Now, at the end of the Marshall Court, we see the limits of that, and you've got a very different president in Andrew Jackson, who will not cooperate with the court on the matter of Indian removal. So we sort of have the first instance of, we talked about in the last videos, of the weakness of the court, and all they have is their judgment. Adam Jackson made it very clear that that's a nice judgment, Marshall, but I'm not doing anything about it. And off the Cherokees go to Oklahoma. So I really, in terms of connecting it to modern times, I don't think anybody's arguing about, that the court shouldn't have judicial review. I think this could come up in just what are the limits of judicial review. if the court was to issue, on this matter of Trump having to turn his tax records over to an investigator out of New York State, if they were to rule that he had to, yeah, I think he'd be awfully tempted to say, I'm not going to, make me. And then we're going to have impeachment too. I mean, how many sequels do we need on all of this? Of course, all of this is on hold now because of what's going on. So this is just a very brief walkthrough of these cases. We have two more big things or I have two more big things to record videos on, and that's civil rights and civil liberties. There's only two questions. I don't know how this is all going to play out. We'll just have to see and make the best we can. And this is inconvenient and a challenge, but in the grand scheme of things, what the area and the country and the world is going through, it's small potatoes. So I'll be recording a couple of more and be working with you electronically down the road.